here with Minnesota Press, coming at you live on March 31st, 2025. Time is about 1:04 p.m. We're here at the Crow Wing County Judicial Center. And the reason we're here is because our 1A speech rights are taking a licking, folks. The first thing that happened, a state representative deleted comments and blocked a man from his official state rep Facebook page. Now, if he wants to do that on his personal page or his campaign page, he certainly has the right to do that, but not on his state representative page. That is a deprivation of First Amendment speech rights, as described in Linkey versus Freed, a U.S. Supreme Court from 2024. The reason Linkey lost his appeal is because Freed's Facebook profile was primarily and prolifically for personal use. That is not the case here. The state representative's State Representative Josh Heinzman, his Facebook page was primarily and prolifically for state business use. He has a personal page and a campaign page for other purposes. So that's what makes this case different than the Linkey case. Now, the plaintiff, the defendant's motion to dismiss prevailed. The judge granted the defendant's motion to dismiss in this case. The plaintiff appealed. The granting of the motion to dismiss happened the end of January. I believe it was the 29th or the 27th or something like that of January 2025. And the appeal was filed on February 27th, I believe was the date the appeal was filed. You folks might or might not know, if you're on medical assistance or any type of assistance from the government, you are entitled to a fee waiver so long as your case is not frivolous. Okay, so the court granted my fee waiver in order to litigate the case to begin with. However, when I went to file my appeal, the fee waiver goes through the district court, and the district court denied my fee waiver for appeal, calling the appeal frivolous. Okay, and that is the district court's way of evading review. In addition to that, the defendant filed a motion for cost bond, attempting to get the plaintiff to pay the maximum $1,000 cost bond in order to continue on to appeal. The defendant cited two other cases in his motion for cost bond. A 2024 case to get the defendant removed from the ballot. And what's interesting about that case is the defendant's counsel filed the exact same petition against an independent candidate back in 2010, trying to get the independent candidate removed because he wrote independent instead of independence on his application, on his affidavit for candidacy. Hey, Pinky, how's it going? In this case, the defendant wrote Republican instead of the official title Republican Party of Minnesota, and so a petition was filed in order to get him removed for not using a major political party name in his affidavit. So that is one of the cases the defendant cited. Another case the defendant cited is an OAH complaint for campaign violations. His signs did not contain disclosures that were prominently displayed, and the OAH found prima facie or prima facie, or however you pronounce that word, the OAH, the Office of Administrative Hearings, found prima facie probable cause. However, the legislator baked a section of statute in that removed jurisdiction from the OAH and gave it to the CFB in those cases, the Campaign Finance Board in those cases. And so the judge had no choice but to dismiss that. The defendant attempted to soak the plaintiff for attorney fees in the OAH case, calling the complaint frivolous. The administrative law judge with the OAH deemed it to be not frivolous, and of course denied the defendant his attorney fees that he was trying to shake the plaintiff down for. So those are the cases that he's using in this motion for cost bond in order to try to show that this First Amendment case is frivolous. And there's nothing frivolous about this. If there was nothing frivolous about the Linkey complaint against Freed, there's certainly nothing frivolous about this, because this case rises to the occasion where the Linkey case fell short. So here we are, we got our fee waiver denied, and we're facing a motion for cost bond here today at the Judicial Center. I don't know what to say about this, guys. I motioned for a review from the Court of Appeals on the denial of the fee waiver. The Court of Appeals remanded it back to the district court. So the district court can't add to the record. The Court of Appeals found nothing in the record to suggest that the appeal is frivolous. I mean, the complaint itself wasn't frivolous. They granted the fee waiver to begin with on the complaint. So what's the problem here at appeal? I think it's that the judge knows that she made an unlawful judgment and order, and she is attempting to evade review. And of course the defendant has no problem going along with no review as well, because of course they won. So of course they don't want to review either. So that's what we're looking at. Just a quick update. Thanks for joining, guys. I might hop on here after this just to make sure I let you guys know I made it out of here alive. Court hearing starts at 1:30. I better go in there and get used to my surroundings and make sure I'm prepared for this. Whatever circus comes next. Thanks for joining, guys. Until next time, law-abiding Minnesotan with Minnesota Press out.